Thank you for joining the Federalist Society panel, Regulating Social Media. It's hosted by two practice groups, Corporations, Securities and Antitrust, and Telecommunications and Electronic Media. I'm Dwayne Benton, a judge on the 8th Circuit. I'll be the moderator. This panel will discuss regulating the biggest companies in the technology space, including the internet service providers that connect all of us, and the near ubiquitous social media platforms. This is a pivotal point in communications and antitrust. American edge companies, Amazon, Google, Facebook, Microsoft, are the world's most recognizable and profitable. They produce massive consumer benefits. One click, our favorite products appear on the porch. Another click or two, endless knowledge, incomparable search engines. And with software, we can, like today, easily connect with old friends, family, colleagues, courts, no matter how far away we are. The issue, how to regulate these companies and the underlying physical networks to accommodate protecting consumers, promoting innovation, encouraging competition. The Department of Justice recently sued Google for, quote, unlawfully maintaining monopolies in the markets for general search services, search advertising, and general search text advertising, unquote. Platforms like Twitter and Facebook are the primary source of information for many, many Americans, enabling us to freely create and share contents with billions of people. With easy communication comes liability concerns. These platforms have a limited shield from liability under Section 230 of the Communications Decency Act of 1996. There's an increasingly political debate about Section 230, whether its protection should be maintained, and if so, at what cost. These debates occur against a backdrop of increasing pressure to invest in the networks of tomorrow, which require massive capital in order to lead the world in broadband and 5G. T-Mobile and Sprint recently merged to become a dynamic new wireless competitor. This sparks questions, of course, about the level of competition in the fixed and mobile broadband markets. What can be done to promote investment? Is net neutrality needed to prevent these networks from becoming too powerful? To make sense of all these issues, we have four distinguished panelists. Let me introduce them, and I'm going to do all the introductions now so that it goes smoothly, speaker to speaker. I'm going to go ahead and introduce our first speaker is Kathleen O'Brien Ham. She is the Senior Vice President, Government Affairs for T-Mobile. The Chief Public Policy Advocate for the Un-carrier. She manages all public policy issues before federal and state governments. Before joining T-Mobile, she worked 14 years at the FCC, including as Deputy Chief of the Wireless Telecommunications Bureau. She was the first chief of the FCC Spectrum Auctions Program, responsible for the early landmark PCS spectrum auctions. She also served on the FCC's Spectrum Management Task Force and the Intergovernmental Advisory Committee that negotiated the reallocation of 3G wireless spectrum from government to commercial use. Most relevant today, she led the campaign, the 2-year campaign to all governments for T-Mobile's merger with Sprint, ending in April 2020. She's received several top lobbyists, most influential, and similar awards. A graduate of Catholic University Columbus School of Law, she's since taught there. She received her undergraduate degree from the University of Colorado, Bachelor of Science, Journalism. We're blessed to have the Honorable Brendan Carr, nominated to be a commissioner of the FCC by President Donald J. Trump, confirmed unanimously by the United States Senate in 2017, 2019, nominated by the President, confirmed by the Senate for a new 5-year term. Previously, General Counsel to the FCC, representing that agency in court, Chief Legal Advisor to the Commission, first joined the FCC as a staffer in 2012 working on spectrum policy and competition matters for a number of FCC offices. Before joining the agency, Commissioner Carr was an attorney at Wiley Ryan in the firm's appellate litigation and telecom practices. He litigated cases about the First Amendment Communications Act. He's a graduate of Georgetown University, clerked on the Fourth Circuit, Judge Dennis W. Shedd, magna cum laude from law school at Catholic University, and editor of the Law Review there. Commissioner Carr grew up in Virginia, now lives in Washington, D.C., with his wife and 3 children. We also are honored to have the Honorable Christine Wilson sworn in on September 26, 2018, as a commissioner of the Federal Trade Commission. President Donald J. Trump nominated her to a term ending September 2025. She previously served at the FTC as Chief of Staff to Chairman Tim Merce during the George W. Bush administration. And while in law school, she was a law clerk in the Bureau of Competition. Between her time at the FCC, Commissioner Wilson practiced competition and consumer protection law, both at law firms and as in-house counsel. When nominated, she was Senior Vice President, Legal, Regulatory, International for Delta Airlines. Previously a member of Washington, D.C. antitrust practice groups at Kirkland & Ellis and O'Melveny & Myers. She graduated cum laude from the Georgetown University Law Center after being Phi Beta Kappa at the University of Florida. She lives in Virginia with her husband and 2 daughters. Our fourth panelist is Harold Feld, Senior Vice President of Public Knowledge, which is an organization that promotes an open internet and access to affordable communications. He is the author of The Case for a Digital Platform Act, a guide to what government can do to preserve competition and empower individual users in the huge part of the economy now called big tech. Former FCC Chairman Tom Wheeler described his book as, quote, a tour de force on the issues raised by the digital economy and internet capitalism. For more than 20 years, Harold Feld practiced law at the intersection of technology, broadband, and media policy, both in the private sector and public interest community. He has an undergraduate degree from Princeton, a law degree from Boston University. He clerked on the DC Court of Appeals. Our speakers will now begin and follow each other without further introduction or interruption. Ms. Ham.
Thank you. Thank you, Judge Benton. Thank you, Dean Reuter and the Federalist Society for the invitation to participate in today's panel. I'm delighted to be here today with your honor and to be among this esteemed group of panelists. I'd like to thank the Federalist Society for its support of the T-Mobile Sprint merger. Your support was very welcome and lent additional credibility to our efforts, and we're grateful to have had your important voices throughout the 2-year approval process. I also very much appreciate the leadership provided by the FCC, especially Chairman Pai, Commissioner Carr, and Commissioner O'Reilly in approving the transaction. I plan to spend my time today highlighting the merger's 2-year review timeline, providing some details about how we approach the anticipated review of our merger by both federal and state regulators and the courts, and how our business plan, which was designed to deliver further innovation, economic growth, and competition in the U.S. via 5G mobile technology, is already delivering benefits to consumers. For those that followed the transaction closely, the approval process went longer than we had anticipated. Announced in April 2018, it was a 2-year review process that was met with a few twists and turns along the way. The transaction required approvals from several federal regulators, CFIUS, the FCC, the Department of Justice. It also required 19 state public utility approvals, commission approvals, including California and New York. The standards for those reviews varied based on the scope of each agency's authority under the law. However, in general, regulators and the courts scrutinized the unique facts of our transaction and applied a consumer welfare standard. From the very beginning and throughout the review process, we felt strongly that our business case was sound, that the regulators and ultimately a federal court would come to understand the engineering and the economics of the business combination. And as a result, that we would ultimately prevail on the merits and successfully close the transaction. The review process undertaken by regulators and the courts remain focused on our business plan to deliver a world-class nationwide 5G network in the US. In June of 2019, a coalition of largely Democratic state attorney generals filed a federal legal action under the Clayton Act. They publicly stated that the transaction was bad for consumers, bad for competition, and would eliminate jobs, and therefore that the transaction should be permanently enjoined from closing by the court. I would note that the decision of the state AG coalition to file a suit occurred prior to the federal DOJ action or an FCC decision. This was unprecedented and ultimately required us to defend the transaction in the latter part of 2019, thereby delaying our original expectation that we would close the transaction in 2019. The federal DOJ did adopt a complaint and consent decree in September of 2019, requiring a divestiture of Sprint's prepaid operations and some 9 million customers to Dish Network. The DOJ also required T-Mobile to negotiate several agreements to facilitate Dish's emergence as a formidable fourth nationwide wireless provider. The federal DOJ consent decree was joined by several Republican state attorney generals. On November 5th, 2019, the FCC adopted an order approving the T-Mobile-Sprint merger. In December 2019, our trial in the Southern District of New York began in front of the Honorable Judge Vincent Marrero. During the 2-week trial, my business leaders from both T-Mobile and Sprint, including our CEOs, our chief technology officers, provided testimony on our business plans. Prior to closing arguments in New York, we received an order in January of 2020 from the District Court for the District of Columbia approving our DOJ consent decree under the Tunney Act. On February 11th, 2020, Judge Marrero of the Southern District of New York issued a 173-page opinion denying the state's request to enjoin the transaction and permitting the transaction to be consummated. The judge ruled that he was not persuaded by the opposing state's position that the combined company would increase prices and reduce quality. To the contrary, Judge Marrero held that he found that the parties' assertions regarding the transaction's efficiencies were persuasive and likely to benefit consumers. Judge Marrero also opined that while the state's case may have been good enough to warrant an injunction in a more traditional market, presumption of anti-competitive effects would be misleading in this particularly dynamic and rapidly changing industry. In March, the state AG coalition announced the decision not to seek an appeal of the Southern District of New York decision, clearing the way for the close of our merger on April 1, during a pandemic and nearly 2 years after the company's business combination agreement was announced. As previously noted, maintaining the credibility of our business plan, which was designed to further innovation, economic growth, and competition in the US via a 5G mobile technology, was the focus throughout our regulatory review process. Through the process, the company also made 400 merger commitments enabled by our business case, which is also heavily founded on the network that is being created. The engineering model and economics of our business plan also serves as a basis for these voluntary commitments, including a 3-year pricing commitment offered to mitigate perceived issues by stakeholders. The merger leverages the massive scale and capacity unleashed by the combination of complementary spectrum and network assets of the two companies and ensures that the combined company delivers consumer and competitive benefits as a result of the transaction. It has only been 223 days and counting since we closed the transaction, and we're already delivering on our promises and demonstrating the benefits of our combination of this business case to build America's best 5G network and offer unrivaled coverage and capacity to our customers. T-Mobile's 5G network now covers 270 million people in 8,300 cities and towns across 1.4 million square miles. That's more square miles of 5G coverage than Verizon and AT&T combined. T-Mobile's been able to deliver on its promise to provide lower cost at T-Mobile Connect, which is a $15 offering with unlimited talk, text, and 2 gigabytes of high-speed data per month. This offer is half the price of the lowest cost offer now in the market. The company has also delivered on its promise to launch an initiative to address the homework gap, known as Project 10 Million. We're providing the country's most in need school-age children necessary broadband access at no cost and during a pandemic. In addition, T-Mobile has expanded its home internet pilot service to parts of 450 cities and towns, laying the groundwork for nationwide 5G commercial launch of fixed wireless broadband. And just 2 weeks ago, T-Mobile continued its past practice of innovation by launching its latest Un-carrier move with the introduction of a next generation streaming service, TVision Live, Vibe, and Channels, and the TVision Hub, a new streaming device. We're committed to delivering further innovation, economic growth, and competition in the US via our 5G network. And our efforts since our deal closed in April are already delivering benefits to consumers, thereby validating decision makers who approved our transaction earlier this year. I'm looking forward to hearing from the other panelists, including their observations regarding our transaction, particularly in relation to the current and future telecommunications and antitrust issues. Thanks again for this opportunity, and I now turn it over to FCC Commissioner Brendan Carr. Thank you.
Thank you so much, Kathleen, for your opening remarks, and thank you for your kind words at the beginning for all the different regulators that had the fun opportunity to touch your transaction. It was an interesting one. I'm happy to get into that a little bit. You know, stepping back more broadly, I think that we are at a really interesting time when it comes to big tech, and a lot of people watching this. And I really wish we were all together in person. I love the Federalist Society week when we can all see each other, usually in DC, but this will have to do virtually for now. We're at this really interesting moment. I think a lot of people over the last 6 months, 9 months have started to hear this term Section 230. Sometimes you see it in all caps in a tweet. Sometimes you see it in congressional testimony, and people sort of say, what is Section 230? Why are we talking about Section 230? And really, I think it goes to a broader debate that we're having within the conservative movement about our approach to big tech. And what I mean by that is a lot of people on the left and Democrats have a very clear agenda of what they want to get done when it comes to big tech, right? They want to break up a lot of these large companies. They want to block new mergers from going through. And frankly, they want to see less speech on the internet. There's all kinds of reasons and justifications that they want for less speech on the internet. They can label it hate speech, which is constitutionally protected speech. They can label it disinformation. They can label it misinformation. But the bottom line is there's a lot of pushback on the left to try to have less information out there on the internet. I take obviously a very different approach to that. I want more speech, more ideas, a greater diversity of viewpoints. And I think a lot of this centers on Section 230. So let me maybe step back and give some context about what that is. Section 230 of the Communications Act is a provision of law that Congress passed back in the mid-1990s. There were a series of cases back then that involved Prodigy and CompuServe messaging boards. People that are my age or older probably remember those. Younger folks might not know what those messaging boards are. But the type of content moderation that took place on those messaging boards is far different than the type of content moderation that takes place today. So when you had those small startup messaging boards, websites, Congress passed Section 230. It does a couple things. One, there's a provision known as 230C1 that in a nutshell says these websites aren't responsible for the speech that other people post on their websites. And frankly, I think that's the least controversial part of Section 230, but it's one that is an outsized part of the debate, and I think in a way that's a bit of a red herring. The more interesting part of 230 is 230C2, which in my view at least, and this is not universally believed, but since I believe it, it should be, C2 provides that if you moderate, if you take down speech, you can do so with the 230 statutory protections if it falls within certain categories enumerated in the statute by Congress, including one where the big debate is about, which is this language that says if you have a good faith belief that the content is otherwise objectionable. So flash forward from those 1990 days when Congress passed that, the CompuServe and Prodigy messaging boards of that day are now Twitter, Facebook, and other, large corporate behemoths. These entities now have more control over more speech than any institution we have ever known. And so then I think it comes to us as conservatives to decide, what do we do? And this is where I think there's been a big fork in the road for conservatives, right? There is a strain of the movement that is influenced rightly in many cases by this libertarian view that the sort of only threat to liberty comes from government action, and that there either is not a problem for us to solve when it comes to big tech, or the solution that the government is offering is going to do more harm than good. I think there's a different way to look at this, which is if you go all the way back to Barry Goldwater, 1960s, The Conscience of a Conservative. There's a line in that book that says the enemy of freedom is unrestrained power, and the champions of freedom will fight against the concentration of power wherever they find it. I think there has been a bit of a, I don't know what the right word is, a slippage, a backpedaling within the conservative movement that some have been myopically focused, singularly focused on the threat that comes from government action, rightly so, right? Only the government can jail you, only the government can take away your property legally. That is a massive threat. But I think in doing so, a lot of people are missing the threat that comes from the unrestrained concentration of corporate power. And that is where I think the big tech debate fits in. And frankly, I think this is a microcosm for a much broader debate that is taking place in the conservative movement, which is, are we going to meet these public policy threats with some form of limited light touch regulation that does involve the exercise of public policy? I think the conservative movement in a lot of ways has a strong element to it that has fallen into this rut of what I would call abject corporatism. If a big company wants it, it has to be in the public interest, and there is nothing for any government official to say about it. And obviously, I sort of reject that view. Again, government can absolutely tread on our liberty, but so can the massive concentration of power that, in my view, is sort of now at an unprecedented level with big tech. So there's two fights, I think, to take place in the conservative movement. One is, do we do anything or do we do nothing? And, obviously, I think I've made my decision and voice on this pretty clear. I think it's time for all of us to step up and defend individual liberty, whether that threat comes from big government or big tech. And I think we can do it without threatening free speech on the internet. And we can do it without going down a socialism path or a big government path. There is a light touch government solution here. Let me quickly say what I mean by that. One is, I think we should reform Section 230, and we should do it in this way. We should take a look at Section 230C2, and we should read that as applying in far more cases than what courts have read it to apply to today. Courts have focused on the 26 words in C1. I think we need the courts to also focus on the other words in the statute in C2. I think we should look at the words in C2 and read them much more closely in line with what I think was Congress' intent as demonstrated by the text. The upshot of those reforms would be websites, big tech, would need to meet a higher burden to take speech down off the internet while also maintaining these special Section 230 protections. Now, let me be clear. That does not mean that websites cannot take speech down. It is not an abrogation of their First Amendment rights. Every website always will have the First Amendment right not to carry speech. The only question is, when they take that speech down, do they do so not only with their First Amendment right, but also with the Section 230 rights? And my view is they should do so as long as they are doing it within the confines of the statute. Second, I think we need to bring a lot more transparency. Right now, big tech is a black box. If you kick off a platform, a tweet gets taken down, there's almost no transparency as to why it happened. And sometimes there's legitimate reasons, but people sort of come up with and add their own nefarious reasons for this conduct because they're not seeing transparent reasons for it. And I think we have authority at the FCC to step in and adopt some rules that would bring some basic levels of transparency as to how big tech operates. And I think there's some reforms around user empowerment. I think we should give people more control to go into their settings and turn off these, what I call bias filters that are applied. If you want Fox News to fact check your Facebook feed before you see it, great, click that button. But if you don't, you should have the option to not have someone else filter your feed forward and make your own mind up. So the upshot of these reforms, which would be transparency, user empowerment, more accountability, which is where I think my colleagues at the Federal Trade Commission could take a stronger position with respect to looking at a lot of this conduct by big tech through the competition lens and competition authorities they have. If we can adopt those reforms, I think we will be in a far better shape of sort of standing up for and preserving really what we should all care about, which is individual liberty. And again, in my view, we'd end up with more speech. I'm pleased to see sort of the progress that's been made along these lines. I mean, again, if you flash back a few months ago, there were a few loud, but not many conservative voices calling for reining in big tech, and that's changing. A couple weeks ago, Justice Thomas wrote a separate statement saying that courts have read immunities into 230 that are simply not found anywhere in the statute. The Wall Street Journal editorial board, an institution that is not known for reflexively embracing government regulation, said that they're open to some forms of reform on 230, while recognizing, I think as we all do, that some reforms could do more harm than good, but they're also looking for ideas for reform. So I think we've seen this mainstreaming now of calls to reform Section 230. I think that's very healthy. I wish that we had moved faster. I've been chomping at the bit a little bit here to make some more progress on 230 reform, but I'm glad to see that the conversation now is where it is, and happy to hear from my fellow panelists and get healthy and welcome pushback on many elements of my views. So I'm going to turn it over to, I believe it's Commissioner Wilson is next up.
Thank you, Commissioner Carr, and thank you to the Federalist Society for inviting me to speak today. So let me start with two caveats. First, I speak only for myself and not for the FTC or any other commissioner. And second, the FTC deals with telecoms only when they're engaged in non-common carrier activity and when we are wearing our consumer protection hat due to the common carrier exemption under Section 5 of the FTC Act. But the FTC does have the ability to enforce against unfair and deceptive practices involving internet service providers. Last year, the Commission issued orders to 7 ISPs seeking detailed information about how broadband companies collect, retain, use, and disclose data about consumers and their devices. The need for this information became especially important as ISPs have become vertically integrated platforms that also provide advertising-supported content. We also have plenty of work regarding social media and big tech. In addition to investigations of mergers and conduct, we are conducting studies in the sector. As an aside, one aspect of the FTC that I appreciate is its ever-present drive to stay abreast of market developments. A government agency that makes policy and enforcement decisions in a knowledge vacuum acts irresponsibly. While we can't have perfect information, we can and do routinely seek industry, academic, legal, and economic input through workshops and hearings and panels. And we also obtain detailed information from market participants through a tool that's known as a 6B study. That gives us the opportunity to collect information from market participants. On the competition side, we're conducting a 6B study focused on prior acquisitions by 5 large tech companies that were not previously reported to the agency. This analysis will help us understand whether potentially anti-competitive deals have been flying under the radar and will inform us whether we need to change our merger notification rules. But it's important to note that this would not be a tech-specific change. There have been industry roll-ups in a variety of different areas like kidney dialysis and hospitals where this phenomenon may also have occurred. On the consumer protection side, I've asked for 6B studies that explore issues arising from the privacy and data security practices of technology companies, including social media platforms. I want us to know whether, and if so, how, content curation and targeted advertising practices impact data collection, use, and sharing, and how the monetization of data impacts the creation and refinement of algorithms that drive content curation and targeted advertising practices. The concern that social media platforms are too much of a black box, as Commissioner Carr mentioned, is bipartisan. When I issued a statement calling for a 6B study, I was joined by one of my Democrat colleagues. The House of Representatives Committee on the Judiciary said it was also trying to understand online platforms when it held a series of hearings for more than a year. The Democrats on the Antitrust Subcommittee issued a report last month through their staff that included a set of recommendations for legal reforms. I will not get into all of my disagreements with the report. They are legion, but I do want to highlight what's missing: recommendations for a comprehensive federal privacy law and for reform of Section 230. In a 450-page report with 2,542 footnotes, there are 0 mentions of Section 230. And yet, Section 230 has shaped the online platforms that the committee investigated. Amazon cites the law as a defense against litigation over defective products that third parties sell through its marketplace. Facebook and Google's YouTube avoid legal liability for what users say, but can attract advertisers by promising to delete or demonetize speech that the advertisers might not want to appear next to their ads. We know that when the government intervenes in a market, competitive dynamics change. This phenomenon is no less apparent when government intervention takes the form of an exemption from traditional liability. Similarly, the absence of a comprehensive federal privacy law has shaped companies' collection, use, and sharing of data, which in turn shapes the business models that companies adopt. Significant information asymmetries exist between users and companies regarding how much and what kinds of data are being collected from consumers and for what purposes. This is the lack of transparency that Commissioner Carr referred to. Perhaps if consumers better understood how their data is collected, used, and monetized, they would make different choices about which products and services to use, and business models would need to respond accordingly. But rather than target what many Americans are complaining about in their dealings with online platforms, a loss of privacy and concerns about censorship of valued content, the House Antitrust Subcommittee's recommendations took aim at the whole economy. They said Congress should consider banning a company that's been successful in one market from operating in a different one through the kind of line of business restrictions that Congress once placed on railroads. Interestingly, even though they referenced these railroad regulations at least a dozen times in the report, not once did they mention that Congress ultimately repealed those restrictions because they imposed great harm on consumers, they stifled innovation, and they imposed significant costs on market participants. The report also recommended that Congress make companies that offer deep discounts to attract customers potentially liable for predatory pricing, even if those companies don't later hike up their prices. But at what point did vigorous price competition become unattractive? And the report also recommended that Congress make it illegal for a company to change the design of a product, even if it's an improvement for consumers, in a way that makes it harder for rivals to compete. At what point did we decide to coddle competitors rather than encourage competition for the benefit of consumers? Very interesting questions. I look forward to responding to the points raised by the other panelists, especially this one, Harold Feld from Public Knowledge. Thank you.
Thank you. I have to say that It is a pleasure to be back here again at the Federalist Society, although to some degree it's feels a little bit like being the vegan invited to the barbecue. But I find myself in agreement with a number of important things with regard to the regulation of social media. As is required of anyone who's written a book, I'm required to plug it and note that it is available on Amazon, which, as I like to say, is not hypocrisy, but simply proves my point, that some of these services are indeed large to a measure of being virtually unavoidable. One of the articles that I cite in the book had to do with a reporter who spent a week for each of the major edge companies, Amazon, Google, Microsoft, Facebook, to see if what happened if she blocked all traffic, not just not going to the website, but all traffic that flowed through those servers. And it turns out it is virtually impossible to use the modern internet without touching these companies at some point in the management of the traffic, not just in the content layer. So certainly I've argued, and I agree with those who say that there is a problem of concentration of corporate power. That said, I think that it is important, however, to distinguish between what the Federal Communications Commission does and its role over the networks that provide access, and what the Federal Trade Commission does, or what an independent agency might do with regard to businesses that do not exhibit the same essential qualities that are typically regulated by the FCC, and why, in particular, I think Section 230 is not a good match with the Federal Communications Commission at all. Some of that is just the history. If there was one thing that everybody agreed on in 1996 when they were putting the act together, it was that they really didn't want the FCC to regulate the content layer. How much this extended to questions of the pipes is one of those things which we spend a lot of time debating. I've spent since 1998 debating with people about this. This is the Title I information service versus Title II telecommunications service. But with regard to just the nature of Section 230, I feel it's important to point out a number of things. One is the definition of internet active services, which is used in the statute, is extremely broad. It would place under control of the Federal Communications Commission to a certain extent with regard to its interpretation of Section 230, virtually any service. I will just quote from the definition section, which is 230F sub 2, which defines interactive computer service, which is what's the subject of Section 230, as any information service system or access software provider that provides or enables computer access by multiple users or a computer server, including specifically a service or system that provides access to the internet, and such systems operated services offered by libraries or educational institutions. So if we were to read this broadly, it includes not only Google and Facebook, not only T-Mobile and Comcast, but virtually any home that has a Wi-Fi server that connects to 5 or 6 different devices that then access the internet through an intermediary. It's hard to believe that Congress intended to convey that broad authority to the Federal Communications Commission. I like to describe the FCC's authority as narrow but deep, which is to say it really focuses on the networks and not on any other associated content or service provider, and with very good reason, because the mechanics of the networks are critically important most of the work of the FCC is terribly, terribly dull and terribly, terribly important in terms of things like spectrum management, emergency and resiliency requirement, things that go to the pipes and ensuring that these critical services are open. Now, does that also mean ensuring the greatest possible access to sources of information? As the Supreme Court has said, the conflict of which is the crucible from which truth emerges. Absolutely. That has been held to be a critical issue of the FCC as well. So to some extent, you could argue that, well, a new kind of neutrality requirement around C2 is not wholly out of place. I would argue that it really is in this context, both as a matter of the history, but also as a matter of the question that there really isn't much there for the FCC to interpret. We can certainly argue about whether Justice Thomas is right that the early cases, notably Zarin, were overbroad when judges were perhaps too taken with the internet as a nascent service and extending liability protection beyond what was intended. But courts have also been very cautious in pulling this back to ensure that it doesn't leak into things that we think of not so much as about speech or third-party speech, but about things like product liability and business models. So I do think that these are all matters that the courts have dealt with and should continue to deal with, and that we should not subject interpretation of 230 to consistent referrals to the FCC under the doctrine of expert agency referral when these issues come up. I think that would be quite disastrous. But let me turn to the other area of import that has been brought up, which is the transparency. And absolutely, I agree. I spend a bunch of time, my colleague John Bergmeyer has written a paper about the need for procedural fairness in the administration of these processes that social media and others use for takedown, not just of speech, but also of products like at Amazon. And one thing we've learned very clearly over the last several years is companies are very, very bad at making these judgments. Companies are under constant and conflicting pressure to make judgments about what to label, what to keep, what to promote, what to discourage. And that nobody seems to have figured out a good solution for this that is scalable, so that the only real solution with regard to speech online is competition online. If you think that Facebook is stifling you, while I can say that there are real competition problems, but at least there are other places you can go. With regard to the notice, this is an area where I think, yeah, there should be greater transparency. I would say, though, that the transparency that is being used by these platforms is not significantly different from the network management transparency that the FCC imposes on ISPs. First of all, if you want to say, I discriminate for the hell of it, you can do that. If you want to say, we try to be a forum for free speech, but you know what? We also reserve the right to take down whatever the heck we feel would be bad for our bottom line. You can do that. If you want to say, we have an appeals process and we're sorry that you find it confusing, but this is what it is, you can do that. Those are disclosures. We might want to say, not just with regard to social media, but with other businesses, that the nature of disclosure is critically important. But I do think that the effort to try to leverage 230 here for it is a distraction at best and counterproductive at worst. Finally, because I know I'm using a lot of time here, I do just want to add with regard to the competition report that no surprise, I thought the competition report was actually a very good analysis of the problems. I think that, in fact, we need to make a decision if we agree on a premise that highly concentrated corporate power is, as Senator Sherman put it, a kingly prerogative, and if we would not countenance a king in our political world, we should not do so in our economic dealings, then we need to recognize that, yes, there are affirmative steps that need to be taken where you have strong network effects and economies of scale interplaying with each other that are not present in other lines of business. This is, again, I'll refer to my book for the case for that here. But I do think that the focus of the antitrust report on the lines of business restrictions, various other forms of restriction that prevent or would prevent from leveraging market power from one market into another market have been highly successful in other industries, including the telecommunications industry, the AT&T breakup being perhaps the archetypal example of where line of business restrictions was a positive means of promoting competition, and that we really ought to be very aggressively considering rather than dismissing these recommendations. And back to you.
Well, thank you, panelists. Appreciate all that you've done and all the ground you've covered. Now, does any panelist wish to reply to something someone said, or revise and extend, they say in the U.S. House at least? Does anyone wish to do that in regard to the remarks? I don't see. Does anybody, or something you forgot, or?
Yeah, so this is Christine. I am happy to pick up on the general topic that that was introduced in the conversation of AT&T, T-Mobile by Ms. Ham. Efficiencies is a significant and incredibly important topic. So without discussing T-Mobile Sprint specifically, I can say I am a longstanding proponent of taking merger benefits and efficiencies seriously in merger review. I spoke earlier at a conference this year and criticized the asymmetric treatment of efficiencies in the merger review process. And let me tell you what I mean by that. Right now, the U.S. antitrust agencies and the courts condemn mergers based on vague suspicions of future coordination, suggestive business documents, or structural presumptions about market concentration and how competitive dynamics will play out. But they generally view efficiencies claims skeptically. And the result is that parties in turn see little benefit from devoting significant time and resources to building an efficiencies case that is less likely to win approval for the merger than convincing the agency or court about market definition or the ease of new entry. So they don't take the time to present good efficiencies evidence, which gives agencies and courts more reason for skepticism about efficiencies arguments in the first place. And so we have a chicken and egg issue, or a vicious cycle. And in order to break that vicious cycle, I called for the DOJ and the FTC to adjust their approach. First of all, to treat evidence of efficiencies symmetrically with that of potential harms. I also called on both agencies to provide additional guidance both to the antitrust bar and the business community about what types of efficiencies analysis meet their standards. And efficiencies and benefits played a significant role in T-Mobile Sprint. I won't address that because it's a case brought by a sister agency, but I do think that case raised very important issues about how the antitrust agencies address innovation and the evolution of business models and the introduction of new products, and so wanted to put that out there for consideration.
Thank you, Commissioner. Go ahead, Mr. Feld.
Yeah, I just wanted to respond to that point specifically. It's a good one. And to quote Yogi Berra, predictions are hard, especially about the future. I would say, perhaps unsurprisingly, that I feel that potential efficiencies have been overweighted, particularly for something that is not actually present in the statute. I agree that there is some significant work that needs to be done, which I'll emphasize two things. One, with relationship to the T-Mobile merger. We opposed it, so just so folks know. And part of our concern was that for-firm competition has been working. And the DOJ, FTC, HHI guidelines make this point with regard to market concentration. The approval was based in no small part on the bet that Dish could be forced grown into a fourth national competitor. We thought that was not a prudent bet, but we lost that. So now I would certainly like to see them succeed. But I will also add that one of the things that is perhaps disturbing in the T-Mobile decision, and we saw this also in the AT&T Time Warner decision, is a tendency that we are seeing of judges in a discipline that is supposed to be grounded in economics to look at personalities. And what you see in the AT&T, in the T-Mobile Sprint is a judge saying, well, yeah, there's all this evidence, but I just believe these guys. I believe Charlie Ergen is a scrappy competitor. I believe that these guys, are going to go ahead. And this is not supposed to be civil liability, and injunctions in antitrust should not be matters of intent. There's no mens rea here. I don't have a doubt that Dish would like to succeed as a fourth competitor, but that my personal desire here is no guarantee of their success. So if we are going to talk about antitrust, I think we need to not over romanticize it as being or perhaps antitrust folks like to believe that they're Vulcans just applying economic logic, but their human half peeks through an awful lot.
Thank you, Commissioner Carr. You look like you were going to talk.
Yeah, I can jump in there too. I think, I do think we need a updated approach to antitrust. And when I say that, I'm not going full David Cicilline and adopting sort of a rejection of the consumer welfare standard. What I mean by that is more narrow, which is tools. I think Sprint T-Mobile is a great example of that. When we reviewed this transaction at the FCC, we had, a dozen, it felt like, models, static models, to tell you and identify all the ways that this is going to be harmful. And they're models that were developed years and years ago. And we've applied those same models to transactions over the years. And we know, looking back, that they all ended up being pro-consumer, even though the models would tell you potentially something different. So the challenge, I think, is the conflict between a static snapshot in time model and the dynamic either benefits or harms that are going on. And there's not been enough work, I think, on the antitrust side of models to look dynamically at what's taking place. It's particularly a problem in big tech, right? When you got slow-moving monopolies where antitrust law started, railroads, oil industry, that's one thing. But when you got big tech, so let's say you go back to Facebook, Instagram. Again, I'm not saying unwind Facebook, Instagram, but did we have the tools to actually see in 2011, 2012, how quickly Instagram was going to scale up? I don't know that our tools and models captured that. Similarly with Sprint T-Mobile, a lot of people looked at the combination of the third and fourth nationwide provider in the country, and they said, why do we want to get rid of the fourth? The fourth provider, Sprint, is going to continue to exist because our static model, puts it in amnesty and tells you it's going to. The reality was, for people that were paying attention, Sprint was dead man walking. We were not going to have a fourth nationwide provider, at least not one named Sprint, in short order. So I think our tools aren't adept enough to identify how quickly things can get better or worse and sort of the antitrust side. And then picking up as well on one of Harold's points on, Section 230, you talked about the broad scope of the provision, and I agree with it, which is to say this. However broadly Section 230 applies because of the definition of ICS, information content provider, or the statutory term, that's a decision that was made from Congress. The question, though, is what can the FCC do with respect to that broad range of entities that Harold talked about? I would submit that we don't have authority to be the speech police, as one of my colleagues would say. I don't believe we have authority to engage in sort of thumbs up, thumbs down content moderation decisions for these websites. What I do think we have the authority to do is when Congress passes a statute that has words in the statute, we can tell with authority as an agency, where the statute is in the Communications Act, what those words mean. So I think when you say it's broad in terms of what it covers, okay, I can see that, but I don't think that triggers, I think, the harm that Harold was talking about, which is that could have knock-on effects of sort of extensive or over-regulation of it. It's merely, here's the playing field that's covered by 230. These terms apply to it under the statute. Here's what those statutes means. So I don't think it would lead to the parade of horribles that some might suggest.
I think I talked over Commissioner Wilson. Were you trying to get right back in when he started?
Oh, so I was going to observe that it's interesting that Mr. Feld acknowledged that economics is the appropriate basis for antitrust analysis, because that is actually in some dispute. I think people would like to incorporate other goals into antitrust analysis. There have been a number of different potential goals advanced. And the problem with all of those goals is that they are subjective and they are susceptible to being politicized. And when we say consumer welfare is the goal that we are seeking to advance, it is objective, it is based on economic analysis, it is not subject to politicization, and it provides consistent guidance to the business community about whether deals and conduct are lawful. It provides guidance to all stakeholders about what the law is and how it will be applied. And so it provides the transparency that we need to have faith in our institutions. And so I strongly believe that the consumer welfare standard is the appropriate standard, recognizing, of course, that consumers are employees, are stockholders. And so to the extent people want to think about other roles that citizens have in our society and incorporate those into antitrust analysis, I would submit to you that to some extent we're already doing that, because consumers is all encompassing.
Mr. Feld?
Yeah, just quickly, I would say one of my biggest arguments in favor of a separate regulatory agency to address things like consumer harms that may flow from digital platforms and line of business restrictions is because I don't think antitrust should try to do too much. I do think that while I think there's certainly plenty of room to look at the applicable antitrust standards, I can't claim that I'm sufficiently an antitrust scholar to touch that debate. I'm a telecom lawyer who's learned to pretend to do some antitrust because you have to. But again, I do think that it is a comforting illusion to believe that the current application of economic analysis is not subject to politicization and is again sort of this pure logical function machine that is capable of these determinations. Just the simple question of, do you believe in behavioral economics or not? When is it, what is the impact of network effects that we are finding difficult to understand in terms of consumer welfare and how we measure these things? Is the Amex decision really correct or even a feasible mode of analysis? Or should we alternatively care about exertion of market power on either side of the platform, rather than simply the net effect on both sides of the platforms on in a two-sided market? And what do we do in a multi-sided and more complicated market where market efficiencies struggle against what I refer to in the book as perfect information asymmetry, because you can only see what the large platform which controls the traffic permits you to see? So I think that we need to be honest that the tools in the toolkit, when you think it would be nice if it was always clear when you should use the hammer and when you should use a buzzsaw and when you want to use a drill. But the problem is, even if we agree on what the tools in the toolkit ought to be, there's a lot of disagreement on when you're supposed to use which.
Thank you. Ms. Ham, do you want in on any of this?
Sure. Well, a couple of things. One is, I spent 2 weeks in that courtroom up in New York, and I wanted to address some of this. And, I'm not an antitrust lawyer, but I have to say, Judge Marrero struck me as a very sort of practical lawyer, practical judge, and he really was sort of weighing, and I saw this throughout our advocacy. I mean, there are these sort of very complex, Rubik Cube models that are performed in academia. And then there is sort of like real life businessmen who are building a network and deploying and trying to compete, And so I think what he, frankly, we just had a better case. We had better witnesses than the state AGs had, and we're more convincing. And we had a track record. T-Mobile had a track record of being disruptive in the marketplace. That's our DNA. It's part of our brand. Why would we destroy that? And when it's been at the heart of our success. And so I just think in terms of credibility, I think we just were more convincing. It was a stronger case, and it was also based on millions of pages of material that was filed with the government, there was a lot of underlying substance. And we had meeting after meeting with our engineers and our technicians coming in to explain. And at the heart of the case, it was about putting together very complementary spectrum and network assets that would create an explosion of capacity at a time when the world was turning to 5G. And that increased capacity and the efficiencies that we, grind out of it created huge capability for us to put more $40 billion back into our network deployment, and also just make us a stronger competitor to AT&T and Verizon. And I agree with Commissioner Carr. I mean, and we put a lot of this evidence into the record that Sprint was dead man walking, and they weren't going to be able to succeed in the marketplace. And so I think our case was a strong one, and I know the antitrust experts will evaluate it for years to come. But I think it was the right thing to do in a highly dynamic market. I mean, we have now, cable in our space in an increasingly way. These are big companies with a lot of resources that we're competing against. I mean, T-Mobile just launched our streaming service last week to try to compete against cable. So these worlds are colliding, things are changing. And I think Judge Marrero took into account all of that and came out with a very good and wise decision and a practical decision, understanding that dynamic.
Okay, I see the raised hands, but before we go to questions, let me ask you one. And of course, I'm very unsophisticated on this, but I bet on the mind of many of our 250-ish attendees is the question, what does the election mean for regulating social media? I know the commissioners may or may not want to express it, but that's up to them. But Commissioner Carr.
Well, from my perspective, I hope it means the same thing that it meant before, which is that we need to move forward with reforming Section 230. Again, I would have been happy to do it. I think my public positioning on this has been well known for a while. I hope we continue to go for it. I think there's some people out there that are saying, well, no, if Democrats take over the FCC, why would you give them that authority? And my view is we're not giving them any authority. The statute says what it says. And again, it's not investing the FCC with new authority it's never had before. So I would hope that we would continue to go forward. Again, there's a fundamental sort of difference, I think, between Republicans and Democrats. We're sort of pulling on 230 reform from two different ends. I want more speech, more information, and let people make their own minds up. I think there's some on the left that want to either use 230 reform or other steps to have results in which there will be less speech on the internet. But I'm still, ready, willing, and chomping at the bit to move forward with reform.
Mr. Feld, you look ready to address that.
Well, I mean, it's a couple of things. One is I can't help but note the irony that if you changed the words there to ISP and Title II in what Commissioner Carr was saying, it would have sounded an awful lot like me in 2017 over the net neutrality discussion in terms of what the statute says and whether it's investing the FCC with new authority. I do think, though, here that as a practical matter, and I'm going to assume that Joe Biden has won the election, even if that view is not universally shared by everybody on this call. But it is generally the custom not to move forward with items that are highly controversial during the period of transition. So I would certainly hope that there isn't an effort to try to rush this out in the next month or two. But I also think that while 230 reform is going to continue to be debated, it will probably not be debated at the FCC going forward. I do think that it is ripe for the evolution in the courts, which is where it should be. And that, yes, 20 years after the initial decisions, when the internet is and these services are much more an important piece in our lives, a careful examination of some of the precedents may be warranted. But I think that'll happen where it should, either by Congress rewriting the law or by courts refining the precedents.
Okay, Commissioner Wilson, you want to talk about what the election might mean for social media?
So I hope that regardless of the election, Congress will continue moving forward with federal privacy legislation. We had some strong bills introduced in the 116th Congress, and I do hope that the 117th Congress will get that across the finish line. There is long-standing bipartisan support from the FTC for federal privacy and data security legislation. As I already mentioned, consumers need more transparency about how their data is collected and used and shared. On top of that, we have an emerging patchwork of both state and international laws. The disparate data protection laws drive up compliance costs for companies, and that actually has an effect on consumers in the sense that if larger companies are the only ones who can afford those compliance costs, the venture capital startups and new entrants are not going to materialize. And so in an area where I think everyone would like to see more competition, we won't get it if we don't craft privacy laws carefully. And if the U.S. wants to join the global conversation about privacy and data protection, it needs to pass comprehensive privacy legislation. We also see, especially this year, emerging gaps in sector-specific approaches created by evolving technologies. HIPAA, which protects sensitive medical information stored in your healthcare practitioner's offices, has obviously limited coverage. And so when we wear Fitbits and we have health apps on our phones, we are providing a great deal of sensitive health information that is not protected under HIPAA. And that's become increasingly apparent given the pandemic. And then finally, we have Fourth Amendment implications under the Fourth Amendment test. The question is whether there is a reasonable expectation of privacy. If nothing is private, there is no reasonable expectation of privacy, and the Fourth Amendment gets eviscerated. I believe federal privacy legislation is necessary to secure Americans' federal constitutional rights and to protect against risks of privacy and civil liberties. And so I do hope that post-election, regardless of the outcome, that the 117th Congress will get federal privacy legislation across the finish line.
Great. Ms. Ham, do you want to weigh in on what the election means for regulating, or just pass? You can just pass. And that's what I took the.
Sorry, let me just circle back real quick on
Sure, Commissioner, go ahead.
An important point I think Harold made. Harold raised net neutrality, which is a term we've used to describe different things. I think it's an important discussion because a lot of people, have sort of, at least at the Twitter level of discussion, which is often not the most sophisticated or developed. Sometimes that's just because of the character constraints. But people sort of question, they say, how can you be against Title II utility style regulation of the internet, of ISPs, but be in favor of Section 230 reform? I think it's a fair question. I think the answer is pretty straightforward, which is to say, again, with 230 reform, we're talking about interpreting the words more narrowly, appropriately so in my view, that are in 230. And with net neutrality, we're talking about imposing a whole set of Title II regulations and imposing it, at least back then, for the first time on the internet. The other answer to that, though, is there's a gap in regulation right now when it comes to big tech that has no parallel when it comes to ISPs. Even today, even under our approach where we've, quote, repealed net neutrality, there are rules in place through disclosures and otherwise that AT&T and Verizon aren't blocking, aren't throttling. But put that to the side, there's transparency rules right now as well. We have adopted transparency rules that apply to ISPs. We don't have transparency rules at the FCC that apply to the ICS providers that I think we could apply through 257. So at the end of the day, my answer is one, I think net neutrality the net neutrality repeal is a good approach because it has more regulation through transparency than what we have for big tech. And two, I just think it's a different dynamic entirely, reading words of 230 versus reclassifying an entire service.
Okay, so thank you all for taking the bait on my question. Let me do some housekeeping at this point. First of all, I need to give the CLE password. There are certain states that don't trust the provider of CLE or the attendees. And it should appear on your screen. There it is, TVC14, Tango Victor Charlie 14. We'll give it again after our questions, so you get that. And also, I make a parody of this panel. I was looking at what shows on my screen on Zoom. In addition to Zoom, of course, we have people on YouTube, Facebook, Twitter, our own website, FedSoc's own website. So we estimate the audience 500 to 600, a better estimate. I was given that, so I'll clear the air on that. Very important point of counting noses. We can take questions only by Zoom, unfortunately, not those other platforms. You do the raise hand, and I know a couple of you have been up for a while. I see those hands. Have been up for a while. We'll get to you. If you're on the telephone, if you dial *9, I understand that will have the same effect. And so let's take a question. Mr. Keeter, Mr. Kiter, you've been up for some time. Please unmute for sure. But you are recognized, Mitchell Keeter or Mitchell Kiter?
Hi, Keeter. Yes. The question I have is whether a site can curate speech so much that it becomes its own, sort of on a twist on the Latin maxim of exclusio unius est expressio alterius. And the example I'm thinking of is in the Ninth Circuit. There were two cases, one where Google and YouTube were censoring Dennis Prager's conservative videos, and in court they argued that Miami Herald protects editorial judgments of how or even whether to present particular content. But they were also sued for allowing ISIS to post videos that facilitated a terrorist attack, and there they argued that Section 230 forbids treating Google as the publisher or speaker of content posted by others, which seem to be entirely contradictory positions. So my question is, if the goal is to create a forum, which is what Section 230 said, in a Pruneyard or Southworth context, then why should we allow viewpoint discrimination? But on the other hand, if the goal is to foster autonomy, then why should these sites have immunity that would be unavailable for newspapers?
Well,
Mr. Carr looks like he's ready to talk. Go ahead.
Yeah, thanks for the question. I think part of this is there's been a bit of a misperception of how 230 operates today. Some people say that 230 was a deal where you act like a neutral platform, you get 230 protections. If you want to engage in viewpoint discrimination, you don't. That's not the terms of the statute as it is today. It's basically you can engage in content moderation or you cannot engage in content moderation, and you have 230 protection. In my view, I think court cases have gone too far in terms of how they've interpreted the text of 230. You started with a question that I think is, at least I thought you were going with a question that was interesting, which is at what point do the websites become responsible for speech? Because 230 only applies to short-circuited other people's speech. And there's an interesting case, roommates.com, that basically says when a website gets so involved in sort of controlling and determining the choices that people make, like roommates.com was a case where you had a drop-down menu, and that sort of confined people's choices. And some of the drop-downs could be illegal housing criteria, that they were the publisher, to use a shorthand, of the content in that circumstance. And I think that's an interesting question. When you look at the scope and scale and degree of choices that take Twitter is making right now, and how they present other people's speech, at what point does it start to blend and look more like Twitter's decisions about what speech to promote and less like other people's speech? I think that's an interesting question. When Twitter puts these fact check labels on tweets, whether it's the president's or otherwise, that is clearly Twitter's speech, whether you want to call them a publisher or not. And Twitter does not have 230 protections with respect to those fact check labels that it puts on.
Mr. Feld, you look ready. Go ahead.
Yeah, just amusing coincidence. I happen to have been in the same courtroom where Prager was being argued in the Ninth Circuit, because I was arguing a case against the FCC on an entirely different subject. So I actually saw the oral argument on that case, and I do have to say it's important to understand that the supposed censoring that was occurring was actually this sort of labeling where the subject matters that were being discussed in the Prager videos, YouTube decided, parents are going to flip out about that, so we're going to label these as adult, mature, whatever. And you have, if you are a YouTube user that enabled parental controls, then you wouldn't see them. But if you're like 90-something% of other YouTube users, you would see them. This illustrates one of the problems of what people tend to call censorship, because, again, the statute is actually very clearly designed to encourage websites to make these decisions about, well, do I think that this is insensitive? Am I going to empower parents to make these decisions? In fact, there's a separate provision, C3, which arguably could have protected YouTube in this case, because it says there's no liability for telling parents about tools for empowerment and for letting them be empowered. So I think that the expectation of how this encouraged free speech was to prevent services from being overly conservative in what they would allow, which, if you go back to 96, was the argument that Prodigy was found liable because it said we're going to try to make this a family service. That didn't scale up. So the argument was, well, we want folks like Prodigy to take that opportunity and not worry that if they are unsuccessful, that they will be held liable. So really, the issue here is not as if we were back. I hate to use this analogy, but folks here will find it amusing. You don't want the fairness doctrine, which imagines that there are only 3 major networks and maybe 8 full power broadcasters in your market, where in order to deal with the editorial decisions of a platform, you really got to make sure that they're, being neutral, where instead what you want is to create a wealth of platforms so that, if you want to do, just liberal speech, you go here. If you want to do conservative speech, you go there. It's true that the largest platforms are those that are general purpose platforms, but to some degree, that is a function of the fact that they are general purpose rather than specialized.
Let me get some more questions in. Before I do, let me do the CLE password again. We'll see if we can get that on the screen. The TVC, there it is. 14 for you. TVC 14 for those of you that need that. Mr. Stovall, you've been up the next longest. You're recognized. Be sure to unmute. Not hearing you, Mr. Stovall. We'll give you another moment. I don't hear. Sorry about that. Okay. Then we'll go to, I bet it's Mr., but pardon me, I only have that to guess by. Suzuka, it would be my guess. And you are recognized. Is that function? Looks like you're there. Unmic. You're on our screen, so please unmic. Unmute yourself. Oh, that's Mr. Stovall who now appears. Mr. Stovall, would you try to unmute? Sorry, bouncing ball here. Oh boy. Yeah, well, you did for a second.
I think this is unmuted now.
You're fine. Go.
Okay, good. Great. Thank you. Sorry about the technical problems.
Not to worry. Go.
Yeah. Okay. So if you look at the deregulation of the American railroad system, it was a mature business sector. It was affected by government subsidization for 50 years. Take a look at that as an analogous system. It may not match. Take a look at the United States government. And when it established the internet, billions of federal dollars from the Treasury were appropriated for decades through the Defense Advanced Research Projects Agency, DARPA. So can't DARPA be used as a foothold to start allowing more free speech? It's a point that when you deal with the free speech issue writ large as your primary issue, if you just take a clean cut it that way, do you see a means, does anybody in the panel see a means of effective regulation to allow a more robust speech component to social media?
Okay, thank you. Good question. Who wants to tackle it? Unmute if you want to tackle it, panelists. That's what Commissioner Carr, go ahead.
Yeah, I mean, the reforms that I've put forth would produce the result of more speech on the internet. I mean, again, baseline First Amendment is out there, so these websites can make any decision they want consistent with their First Amendment rights. The question for us is, can they also make those decisions with 230 rights? In a lot of ways, I think 230 has been a thumb on the scale, whether intended or not. The practical upshot is in favor of, and I'm speaking specifically C2 here, not C1, of taking down more speech. I think if we can return to the original meaning of C2, which I think is a higher bar on content providers before taking down speech, the upshot of that is going to be a result in which there's more speech on the internet.
Anybody else want to reply in any regard? I don't see any. Well, and I think it's Mr. or Ms. Suzuka, S-C-O-K-A on Zoom. If you want to try, there, you're there. Unmute, go.
Thanks, Soka. I have to say I'm disappointed that the Federalist Society didn't include Section 230 expert here to respond to some of the claims that Commissioner Carr has made today. He's misrepresented almost every aspect of the statute. But I'd just like to ask about a few things in particular. Number one, he would have you believe that it was some sort of liberal plot to reinterpret Section 230 when in fact the decision he's referring to, the Zaran decision from 1997, interpreting C1 as applying to protect the editorial discretion of websites generally, to remove content as well as to put it up, was written by none other than Harvey Wilkinson, a lion of conservative jurisprudence. That is the interpretation the courts have taken today. He's offered no reason for thinking otherwise. He simply presents C2A as an alternative for covering content moderation. In fact, they serve very different purposes. C1 protects content moderation only if you don't produce the content. C2A protects it regardless. So I'd like to hear his response to Judge Wilkinson's analysis in Zaran. But two other quick questions. He also claims that the FCC ought to be able to issue disclosure rules just like it does for broadband. But of course, the FCC's broadband rules apply by definition only to broadband providers that do not edit the services they provide, that do not exercise editorial discretion. That's what the DC Circuit said in upholding those rules and why the DC Circuit said the First Amendment was not implicated. Here, we're talking about the very opposite. He wants to impose disclosure requirements upon services that engage in content moderation, and he wants to compel them to describe in detail how they exercise that content moderation in their editorial discretion. And then finally, he keeps saying he wants to see more speech online. The speech he's talking about removing from the protections of Section 230, the things that he doesn't want websites to be able to moderate are racism, hate speech, misinformation, foreign election interference. This is the speech that he's talking about specifically. These are things that Section 230 protects today in content moderation. And under the administration's proposal to rewrite Section 230, these things would no longer be protected. This makes the administration's proposal obviously not content neutral. It is obviously putting a thumb on the scales and implicating the First Amendment in ways that the administration has not explained.
Okay, thank you. Commissioner Carr, I think.
Thanks. I wasn't sure at first if that was a Zoom bomb or a real question, but I'll try to parse some of it there. I think, one question was about the transparency rule that the FCC applies. There was a suggestion that the FCC's transparency rule only applies on the condition that the entity that it applies to is not editing or not neutral. That's not the case. The FCC's transparency rule came from 257, which was a different provision that was not necessarily tied to the common carrier neutral carriage status. So I do think we have a path forward for reporting obligation that would apply to non-common carriers. And I would just suggest, taking a look at Justice Thomas's decision that walks through some of the judicial interpretations of the Section 230 provisions, and his view being that courts have given expansive readings to it that are not found in terms of the immunities there present in the statutory text itself. And so I'm very comfortable going forward. And there's also a suggestion that the upshot would be a prohibition on entities taking down what was classified by the caller as hate speech or misinformation. Again, I think there's a bit of a sleight of hand happening there. The idea here is that websites can always take down any of this conduct, any of this content. It is not an obligation to keep hate speech up. It is not an obligation in a fairness doctrine sense or what we have in a cable must carry sense to carry this. It is simply when you decide to take it down, if you choose to exercise your First Amendment right to take it down, does that decision also fall within the statutory confines of Section 230? That's one that I think we're well positioned at the FCC to shine some light on those statutory terms.
Well, if I may, I will take issue with the last statement. I'll also take issue with that was Barron, and it was not a Zoom bomber. He's very well known and respected in these circles, even if I personally find that we have sharp disagreements on occasion. But the other thing, though, is that last statement, which I think it's important to illustrate the effect here, which is technically it's true, but that is to say it would still fall within the discretion of the company as to what to do. But to imagine that these companies will not be influenced by potential liability decisions, I think is simply not realistic. The companies are quite litigation averse. And when you change what has been, whether you think 230 is correct or not, I think that we would have to agree that it has become a well understood pillar of internet law as it exists today. And if we are going to start pulling bricks out of this and change the balance of things, and not in the sort of deliberative common law way that courts do, but subject to a new agency interpretation that would itself be subject to litigation, we have to imagine that companies will take the most conservative view, which is to leave things up.
I must interrupt you
I'm
to
sorry.
say that we've reached our time. No. I want to thank you and the other panelists very much. Our audience today, special thanks to the chair of the telecommunications group, Brian Tremont of Wilkinson Barker, for helping me particularly and the whole process. The next convention event is a discussion of our MDL judges too powerful. And that begins at 3:45 Eastern. And I know everyone out there is applauding for our panelists, and I'll give it this. I could clap, but and I could even be loud, but it still wouldn't have the effect. But thank you very much, and good day to everyone.
Thank you.
Thank you.
Thank you, everyone.